ọmọ aláṣọ tó wá wà nísà ọmọ ẹlẹ́nu tó tún wá jẹ ẹ̀wọ̀n ọmọ onílé tó ń sùn tàbí ẹ̀rù àsìkò ti tó àwùfẹ́ mọ́ ẹja lọ́rọ̀ kan lẹ́nu káṣọ gbogbo papọ̀ ká má ṣe ra wa lọ́mọ ìyá Haúsá. Ìṣọ̀kan Yorùbá òmìnira Yorùbá ọwọ́ èmi àti ẹ̀ṣà ló wà. Ìṣọ̀kan Yorùbá òmìnira ló jẹ́ wá lógún àsìkò tí tó. Ìṣọ̀kan Yorùbá òmìnira ló jẹ́ wá lógún àsìkò tí tó. Àìpọ̀ ọmọ ejò ló jẹ́ ejò nígbà ló ń fi ikú pa wọ́n tẹ̀lé ti paramọ́. Tó tún bá tẹ̀. Ọlọ́dẹ náà dáadáa lórúkọ wọn ẹ̀tẹ́ ló. Tọmọ Oǹdó bá tẹ̀ lọ́mọ rẹ̀. Tọmọ Kogi àtọmọ Kwara. Bá fún ìṣọ̀kan ohun tó máa dẹ̀rọ̀. Òmìnira ló yẹ wá ó dẹ̀ máa tẹ̀ wá lọ́wọ́. Tá bá ṣe ra wa lóṣooṣù ọwọ́. Ìṣọ̀kan Yorùbá òmìnira Yorùbá ló jẹ́ wá lọ́wọ́ rẹ̀. Ìṣọ̀kan Yorùbá òmìnira Yorùbá ló jẹ́ wá lọ́wọ́. Ṣàníjì lórúkọ tèmi ṣòfin Yorùbá òmìnira Yorùbá ló jẹ́ wá lọ́wọ́. Ọmọ dúdú wa bẹ́ẹ̀.
Comment and share.
Èmi àti yín ni ìmọ́lẹ̀ ògo adúláwọ̀. Gbogbo apáta lónìí ni ìmọ́lẹ̀ ògo adúláwọ̀. Olódùmarè ọba tó fi èmi àti yín ṣe ìmọ́lẹ̀ kò ní jẹ́ kí ìmọ́lẹ̀ nìkankan wa kò ní jẹ́ kó wọ ọkàn lónìí. Adúpẹ́ fún ọmọdé, adúpẹ́ fún àgbàlagbà, adúpẹ́ fún ọkùnrin, adúpẹ́ fún onílé, adúpẹ́ náà ni adúpẹ́ fún lónìí tátùjọ máa jọ ṣe lónìí. Yorùbá oníkókó báyìí òun náà ni egun yán sùkú báyìí òun náà ni egun àgbàdo. Orúkọ tèmi yí padà Omoboriowo ayé kò tọ́ òun náà ni èmi jẹ́ lónìí. Èmi ni akọ́ mo ń bẹnu lé pẹ̀lú wa bàbá wa tí wọ́n máa bá wa sọ àwọn ọ̀rọ̀ ti tòní wọ́n ń bẹnu lé pẹ̀lú wa bẹ́ẹ̀ la tún ní àlejò náà pàtàkì bàbá wa Sani Lambe akínyìn pé káàbọ̀ sórí ètò fún tòní. Láì ní rí ọjọ́ mo sọ lókàn yẹn wa bẹ̀yìn pé kí ẹ má bínú wípé àráyè ṣe ètò wa ní ọjọ́ Thursday bẹ́ẹ̀ la tún ṣe níjọ́ Sunday. Yorùbá wọn ní tí ò bá nídìí wọn ní obìnrin òkì jẹ èkúmọlú òní àtúntìdé pẹ̀lú yín bá sì jọ máa jọ ṣe ètò tòní. Kí sì ni àkótó náà ní roadmap the 1914 Amalgamation Bridge of Understanding tí mo bá gbà á mo rò pé òun ni tí a máa discuss òun náà ní tòní. Olódùmarè ọba tí ó jẹ́ kí ojú wa kó tún rí òní yóò jẹ́ kí a rí òní pẹ́ láṣẹ Olódùmarè ọba. Bàbá wa tún bẹ́ ń lé tí wọn yóò máa bá wa yànnàná àwọn ètò wa lónìí bí a ṣe máa sọ. Ó kí bàbá wa Dr. Olúṣọlá òní mo kí wọn káàbọ̀ sí orí ètò wa fún tòní. Ẹ káàbọ̀ sà.
Ẹ káalẹ́ o, ẹ kújọ́ mẹ́ta ṣára lé o.
Gbọ́ yín sà.
Thank you very much. Mo ń sọ̀rọ̀.
Ok, oya à ń gbọ́ yín bọ́yá oya ẹ bẹ̀rẹ̀ sà a ti ń gbọ́ yín.
All right, okay. Mo kí gbogbo ilé, mo kí ọkùnrin, mo kí obìnrin, ọmọdé, mo kí àgbà. Ẹ káàsìkálẹ̀. Thank you. I hope that you have learned something or gained something from all the programs that we've been making. Voice, I don't know. Today, I'm going to talk about another roadmap to the Yoruba nation. This is the 1914 Amalgamation. Before I start, I think before I start, I should explain certain things. The amalgamation was in 1914. It's a long time ago. Many waters have passed under the bridge. We should let sleeping dogs lie. I will say two things. The first thing is that Nigeria's border was changed to exclude the Bakassi Peninsula, which was then handed over to the Cameroon. And it was changed on the basis of a treaty that was signed in 1913 between Britain and Germany. So when we are talking about something that happened in 1914 or 1913, the law does not say it is a long time ago. And certainly in the case of the Bakassi Peninsula, it was not a long time ago. The second important thing that I hope, even if you don't understand anything else that I've said about the law, I hope that you will understand what I'm about to say, because I think this is vitally important why we can go to court as individuals or as groups. There is something called tort law, and it started this way. A woman bought a bottle of lemonade. She drank the lemonade and then became ill, and then found that there was a dead snail in the bottle that was causing her to be ill. Her lawyer advised her not to sue the person who sold her the bottle of lemonade, but the manufacturer of the lemonade. The idea was that the manufacturer of the lemonade owed the drinker a duty of care. He needed to be sure to take care that the thing that he produced will not cause somebody else to be ill. And that it was foreseeable that if you have snail in the drink, it was going to make you ill. Now, let us now come forward and think about the amalgamation. The problem that we have in Yoruba land today, what you and I are suffering today, is because of what was passed in 1914. Yes, Nigeria is the one that is causing us the wahala. But if 1914 hadn't occurred, hadn't happened, we will not have the wahala that we have today. So that is why it is possible for me, you, or any of us Yoruba people to sue the British government to say, if you did not do the amalgamation in 1914, I will not be suffering as I am today. So I hope this explains in layman's terms the concept of thought law, that if you are manufacturing something, if you are creating a nation, you need to be able to foresee that the nation that you are creating is not going to cause wahala in the future. And this is very, very important. I hope that I've explained this as best as I can. This is why it is possible to sue Britain, the British government, to say, if we didn't have amalgamation in 1914, we wouldn't be having the wahala today. And I've couched this, I've given this, what we are talking about now, as a breach of undertaking. That is, before the act of, we're not talking of the act of amalgamation now. We're not talking about the law, whatever it is, the act itself. That is, the act on the 1st of January 1914, which brought Yoruba land into Nigeria. That act is a breach of understanding. A breach of undertaking. Now, an undertaking is a commitment made to another person to do something upon which the other person could rely. Do you understand that? If I give you an undertaking, I say to you, I say to a woman, oh, I'm going to marry you. And then I didn't do it. That is, I'm giving her an undertaking. She's entitled to sue me. And I think actually in Nigerian law, this is Nigerian common law, because an undertaking has legal force behind it. An undertaking is legally binding. A treaty, for example, is an undertaking. It has legal force. So we come to the treaty that the Queen Victoria of Britain concluded with Yoruba land on the 23rd of July, 1888. That treaty was ratified on the 16th of June, 1890. So we are not talking of the concluded treaty, they didn't do anything. No, the treaty was ratified. That is, it became law on the 16th of June, 1890. The 1888 Britain-Yoruba Treaty established a legal relationship between Britain and Yoruba land. So there's a legal relationship between the two entities. Britain on one side, Yoruba land on the other side. I know Nigeria is in the middle, but remember what I was talking about, tort law. It is because of this relationship that you can say that Britain committed a breach of undertaking. And what were the undertaking in the 1888 treaty? Number one, the first undertaking was to recognize the Yoruba land as a state with its own borders. They had to, because you can't, only states can sign treaties. And therefore, to sign treaty with the Yoruba land, Britain recognized Yoruba land as a state with its own borders. Britain undertook to conduct preferential trade with the Yoruba people. Not just that the proceed from that trade was to be used specifically to develop Yoruba land. It wasn't, the proceed of trade wasn't to give Nigeria to go and develop northern region. No. The proceed of the trade was specifically designed to develop Yoruba land, nowhere else. Because this was a non-cession treaty, Britain also had an undertaking to safeguard the integrity of the territory of the Yoruba peoples. And the fourth undertaking was to imbue the Yoruba state national treaty to prevent the French from coming to Europe. Finally, the undertaking from Britain signed a treaty, and that was it. It was some kind of a joke, which some historians, some commentators tend to think or are trying to say that this is some kind of joke, but it isn't. The Yoruba people placed reliance on it. William McGregor was governor of Lagos. He said that the treaties that the British concluded with the Yoruba were imbued with legal force, and that legal force constrained Britain, and the treaties were to be honored as long as they continued to exist. So as long as the treaty were in existence, they were to be obeyed. That's William McGregor, governor of Lagos. He then went on to say this, which is very, very important. He said, the treaties informed the Yoruba peoples that their provinces were independent states. So when they signed the treaties, they believed that their provinces were independent states. He then went on to say the native authorities, not unnaturally, begin to think they are entitled to the privileges and rights of great powers. And they didn't just sign the treaty as if it was some kind of a joke. They signed the treaty because they now discussed the undertaking, and we've said the Yoruba people relied on the undertaking. And what is the breach? The breach is simple. In 1914, Britain stopped doing the things that it committed. Britain had an undertaking, a series of five undertakings with the Yoruba land in a treaty that he signed on the 23rd of July, 1888. Britain knew, according to the governor of Lagos, that the Yoruba placed reliance upon those treaties that Britain had concluded with them. So what happened? On the 1st of January 1914, Britain unilaterally incorporated Yoruba land into Nigeria by an act of amalgamation. The act of amalgamation was based on an order in council that was made by the British King on the 22nd of November 1913. That act of amalgamation was a breach of an undertaking that Britain had made to the Yoruba people, in 1888. What the breach of undertaking did was this: one, it removed statehood from the Yoruba land. So the Yoruba land was a state, which was the undertaking. They then did the amalgamation, and they removed statehood from Yoruba without asking us. For administering Northern Nigeria. And thirdly, Britain usurped the sovereignty of the Yoruba land. We didn't cede any land to them. They didn't conquer us. Nevertheless, they usurped the sovereignty of the Yorubas of the 1940 amalgamation that I think it is important that I point out. The first one is this, that the incorporation of the Yoruba land into Nigeria was cynical, and it was done with frivolous and improper intent. These people they just did not care. I mean, okay, let's leave emotions out of it. This is what Lord Harcourt, the colonial secretary, this is what he said. He said, we have released northern Nigeria from the leading strings of the treasury. The promising and well-conducted youth is now on an allowance of his own and is about to effect an alliance with the Southern Lady of Meads. I have issued the special license, and Sir Frederick Lugard will perform the ceremony. May the union be fruitful and the protectorate of Nigeria today, the southern counterpart, can be fairly described as the rich wife or the woman of substance and means. A forced union of marriage, and marital bliss for both husband and wife for many years to come. It is my prayer that the union will last forever. So these people were so cynical, they were so blasé about incorporating Yoruba land into Nigeria. Most of all, at the time of expressed that they did not want amalgamation. This is what Lagos Weekly Record. It says this. Let us hope that with the departure of Sir Frederick, the Nigerian system, the product of his exuberant imagination, will be consigned to the limbo of oblivion. We are embedded in the historical strata of British imperial colonization. It will exist as a facilitator. In other words, when the Yoruba people could express themselves, they did not accept the amalgamation. And remember what I said earlier, what the governor of Lagos said earlier, that the Yoruba expected from and even in his 1919 report to Parliament, Lugard himself confirmed these treaties. In Nigerian court, in the case of JF Investment Limited, I don't know whether anybody is writing any of this now. There was a case of JFS Investment Limited versus Brower Line Limited. The importance of that case was this. That case established that by the 1st of October 1938, assumed all obligations and responsibilities of the colonial regime of the government, which arose from valid international instruments. In other words, the 1888 Yoruba-Britain Treaty became a carry independent state of Nigeria. Was so having carried over the treaty to Nigeria reserved by section, I don't know if anybody is writing this down, I'll read it if you like. That treaty was protected and preserved by section 3.1 of the Nigerian Constitution Order and Council 1960. By section 1561 of Nigeria's 1963 Republic Constitution, and by section 315 of the Fulani 1999 Constitution. So, if I go through this again, I mean, I'm sorry if it's boring. If I go through it again, The treaty, the 1888 treaty, was British domestic law because it was made colonial state of Nigeria. At independence, because Nigeria took over all the responsibilities of Britain, it became law of Nigeria. And the 1888 treaty is an existing law of Nigeria because Section 32 of the laws of the Federation says this: enactments omitted in accordance with subsection 1 of this section shall they had not been omitted in the revised edition. In other words, the 1888 Britain Yoruba Treaty in Britain for breach of undertaking, you could also sue in Nigeria because the 1888 treaty. I'm going to finish by doing what I don't normally do, which is I'm going to this case to court. And
that is why I gave you the whole hours to discuss for today, because I've listened to you, then I don't have question. If anybody have a question, even though from the outside nobody has a question, so you are good to go, sir.
okay. So if I were instructing a lawyer, if I were instructing a lawyer and I say, I want this matter to go to court.
Okay.
I want to take it to court in Nigeria, and I think this is important. I want to take this case to court in Nigeria. I know people say a lot of things about the Nigerian judiciary.
Yes.
But say I have decided I am taking this case to court in Nigeria.
Okay.
So I am the plaintiff. But in fact, any Yoruba person can take this case to court, not just me or any Yoruba group. I said. So you are trying to enforce the obligations of the treaty. That's what you're trying to do. And I would do it at the judicial division of the high. What is for obeying the treaty, as it were.
They pay a you for obey 35 pounds.
The 16th of June 1890.
Wọ́n ti tà wá nìyẹn, owó títà náà gbà lọ́wọ́ wọn yẹn náà. Wọ́n fún lówó, wọ́n ti tà wá ni.
No. Say as defendants, and then he can come to a conclusion. So there are different types of action, but this one I will bring it under the originating because the case has matters of law. You don't need any witnesses. The facts are not likely to be disputed because the facts are there. You've got the treaty, you've got the act of amalgamation. This all that needs to be done. It's a question of law. It has nothing to do with witnesses. Everybody is dead anyway. Those who signed the treaty are dead. But we have copies of the treaty, which is still in the National Archives in London, because I've been there to photocopy it, to photograph it. So I know it's there. And we know the act of amalgamation because Lugard wrote about it. So we got those two documents that we can take to court, and both sides can make their argument. That's why you can use originating summons. And what's the petition is, like I said before, by the incorporation of Yoruba land in Nigeria in the Act of 1914, Britain committed a breach of undertaking. But this time, you are going to say Nigeria committed a breach of undertaking because Nigeria took over
British, yes,
in 1960 with independence.
yeah.
Okay, so now you are going to ask me, what are the grounds for damages? Yoruba man damages. It has caused me injuries for which I am entitled to claim damages.
To claim that damage.
Yes. I can go to court and say, I want money, compensation for the injuries that I've suffered as a result of the 1914 Amalgamation. And I've put down 3 things here. I mean, there may be more, but for the purposes of this talk, I've put down 3 things. And in any case, if I'm going to court, will be my letter of instruction to the lawyer. So I will hand this to the lawyer, and then we'll discuss what is the evidence we need, how much money I should ask for, so there are 3 things I've put down here. The first injury that I suffered is loss of benefits that will have accrued to me had Britain kept its undertaking to use trade to develop Yoruba land. Do you understand that? That is, if Britain had used the money from the trade to develop Yoruba land, I would have got more benefits than I had now. That's the first one. Then I've lost citizenship of Yoruba state. If 1914 hadn't happened, I would be a citizen of Yoruba land, or Republic, or Yoruba Nation, or the Confederacy of Yoruba land, or whatever name you call it. So if there hadn't been 1940, the Act of Amalgamation in 1914, I, Bashegun, would be the citizen of Yoruba, a different country from Nigeria. I'll be a citizen of a country that is totally different from Nigeria. So that's another injury that I suffer. The next injury that I've suffered is this, that the benefits that I will have got as a citizen of the Yoruba state, I have lost it. Do you get that? Do you get that? The first I said.
Yes. I got it, sir.
I've been deprived of citizenship. That's number one. Number two, the benefits of being a citizen of Yoruba land, I've also lost that as well. So these are the injuries that I've suffered. So what do I want the court to do for me? So I've now said there's a breach of undertaking. It has injured me. And now I want some kind of compensation from the court. So the first thing I will ask the court to do is to declare that there was a breach of undertaking. That's the first thing. I want the court to say, yes, there was undertaking. Britain breached it. So that's the first thing. I want the court to declare that there was a breach of undertaking. The second thing that I want the court to then do is that since the court says there's a breach of undertaking, I want the court to then say that we will terminate that breach of undertaking. You can't have a breach of undertaking and then the court will allow it to continue forever. No. If the court declared that there was a breach of undertaking, I will now ask the court to order the termination of that breach of undertaking. What that means is that the Act of Amalgamation of 1914 will be terminated. Do you understand the significance of what I've just said?
Yes, sir.
That is, you ask the court to declare that there's a breach of undertaking. If so, you ask the court to terminate that undertaking, that abuse, that breach. And if the court did that, then it means the court terminates the 1914 Act of Amalgamation, which means the Yoruba land is free, without having to fight anybody or do anything. If you win this case, you win independence for Yoruba land. Finally, I will then ask the court to award me damages in compensation for the breach of undertaking. Those damages will, again, I will be discussing it with my lawyers to say, how much money do you think I should ask for? And I mean, I think, how much did they award Igboho for the infraction? Is it 5 million naira or 50 million naira, something like that?
20 million.
20 million naira, exactly. So we know when I'm talking to my lawyer, we know the area. We know the area we're going. That really is all I have to say. I'm happy to discuss all this with the lawyers in the house who know a lot more about this than I do. If you want me to summarize, if we are going to take this case to court, it is going to be on the basis that the Act of Amalgamation of 1914 was a breach of undertaking. Yes, that's what it was. Britain gave us undertaking. The Yoruba believed that undertaking. Britain then breached that undertaking. And the breach has caused me personal damage. And I'm now asking for compensation for the damage that it has caused. I think I'll pause there and then we'll see what other people think.
Thank you, sir. You have spent almost one, even though remaining just only 2 minutes to complete 1 hour. So today I gave you I gave you explained it deeply. I don't know if anybody have, from my own side, I don't have a question for today. So that's why I just want you to explain, because people have been saying, okay, they want Baba to really narrate the story deeply. So I've promised them, okay, Baba will stop for just 1 hour without interrupted, and I did it. So if anybody have the question in the house, they can ask the question. But if there is no question, maybe we can just summarize and then we call it end of today, because now we have spent 1 hour 25 minutes on this episode. So as we promised, that this program will not be more than 1 hour, so that we can be able to have part 1, part 2, part 3, so as we normally did. So if anybody have the question in the house, please kindly unmute yourself and ask the question. If there is no question, I'll Thursday again. Thank you, sir. So is there anybody have question to ask him for session 1561 and then the first edition of Law of Federal Republic of Nigeria 1990? So at least everybody understand what is law say. To me, I'm not a lawyer, but I think we have people in the house who can say something.
Yeah, thank you, sir. Thank you, my dear brother, Mr. Omoboriowo.
Thank you, sir.
And Dr. Oni, it's nice to see you again, sir, and listening to you. Thank you, sir. I may have followed your presentation very carefully, especially using the analogy of the law, the law of thoughts in contract law to explain. I'm just curious, in light of the fact that Nigeria got its independence in 1960, and we've had opportunities to remedy the situation I'll go back to what our dear brother from NINED, Tony Nadi, said some time ago, one of his lectures I listened to, which is similar to this, that every time we have an election and every time we allow a fraudulent constitution to be used to organize such election, by implication, we are allowing the fraud to continue unchallenged. So even if we were independent state, this is where the conundrum comes in. Even though we were independent, we have our own natural boundaries. However, because we had amalgamation, which is, you can call it, we all willingly or through coercion join, whether you call it marriage or cohabitation, and we continue to do so, whether through our politicians, because of our Jegudujera, our own, politicians or leaders. Don't you think it'd be very difficult to then challenge successfully that the BTC have an obligation to discharge to the Yoruba people or Yoruba nation? Thank you, sir.
Okay. I think I can understand the rationale in saying that, oh, because you've been having elections, therefore it means you are complicit in the fraud. But the elections have been rigged anyway. So you can say, so first thing that I will say, that the elections have been rigged. So you cannot, if elections are rigged, you cannot rely, you are complicit in the fraud. And in any case, if you look at the number of people who are alleged to, for example, the last election, less than 10 million Nigerians voted for the president. You are telling me that I am complicit in the fraud when only less than 10 million people voted for the president? And it's the same whether you look at Buhari and so on and so on and so on and so forth. So the idea that election means that we are all complicit in the Nigeria fraud, what are you supposed to do? Then the second thing is that in 1914, you are put in a cage. That's what 1914 was. You are put in a cage. You are put in a prison. And how to get out of it is what we are still struggling with as you and I are talking now. I read to you what the Daily Record said in 1920. So it isn't as if we have not been trying to get out of this prison. People have been trying to get out of the cage. But it's not possible. It's not possible to do it. And we are still having the same problem now. That is, we are trying to find a way out of the cage, and we are having difficulty doing it. So, but if we go back to the snail in the bottle analogy, it doesn't matter what Nigeria does or doesn't do. It doesn't matter what has happened in Nigeria or has not happened. What happened in 1914 is responsible for the damages that I'm suffering today. That's the point that I'm making. That is the point of tort law. When Lugard with the rest of the country, I'm talking about the act now. I know he didn't make the law, but the very act itself is what is the breach. He knew from what was said, from the frivolous way that they were talking, that what they were doing was wrong. And Nigeria cannot, whatever Nigerians have done or haven't done, cannot wash away the fact that what they did was wrong. And they knew that what they were doing.
Mr. Omoboriowo, can I ask another question?
You are free.
Go ahead.
Go ahead, sir. Go ahead, sir. You are free, sir.
Okay, let me separate into two parts. Part one, we can argue that post 1914 amalgamation. I think you're probably absolutely right, saying that amalgamation put us Yorubas in a very precarious situation, and it's part of why we find ourselves where we are. Therefore, as you rightly said, we deserve, or you deserve, compensation for that. However, the second part is when they actually say, you know what, you guys are now free to have your independence. Our leaders that time had the right to say, you know what, we are not happy with this amalgam. And if Britain can also argue that actually, since we allow you guys to continue that marriage yourself, when you could have voluntarily said, you know what, we don't want to be part of it, you continue up to today.
Yeah.
We have no direct involvement in how you anymore. And I believe one case study that actually supports that. Imagine when an animal is put in a cage, and after a while, you then release that animal, you can go now, and the cage is open. But yet, keep on running into that cage. Do you blame the person who put that animal in the cage in the first place?
But in fact, you've chosen the wrong analogy because that's Pavlovia. By choosing the analogy of the animal in the cage, you have actually that's Pavlovian.
Okay.
You know, I mean that's but what I'm trying to convince you is this. You know, whatever it is in 1914 was a breach of undertaking. Now, you can argue that because, you know, when it comes to compensation now, and I say, I want money, you can then say, oh, well, Nigeria should have done something about yada, yada, yada. But me, look at its stock and examine every bottle to make sure that every bottle is clean. That's not his job. He buys the bottles of ginger ale, puts it on the shelf to sell because he trusted the manufacturer. The same way as the woman who bought the ginger ale trusted the manufacturer. So it is the manufacturer's fault. And we come to the same thing with Britain. The fact
when
of the
does
matter,
the manufacturer's obligation deem discharged?
It's never
just the analogy. It's
until
I know that case very well. But you know, yeah, okay.
It's never discharged because if somebody else bought this thing from him, bought another ginger ale bottle and found another snail, he can still be sued. The woman sued at the time that she was damaged. I am suing at the time that I was damaged. My own children can sue. So can my grandchildren. I cannot, I mean, the pain that I suffer, the damage that I suffer, it's not the same as the damage that my children suffer or my grandchildren will suffer. And therefore, as long as the breach is there, the culpability continues, the liability continues. That is why one of the things I will be asking the judges this. One, tell me that there was a breach of undertaking. If indeed there was a breach, then remove that breach. You can't leave it in place. Now, when it comes to damage, you will see that I didn't put any monetary value on the damages.
Yeah.
When it comes to damages, you can then make this argument that you are making and say, oh, well, Nigerians did independence. But in fact, in order for Britain to be able to say that those who negotiated Nigeria's independence did not raise the question of separation, they have to show us documents. Because that isn't true either. Because the leaders of Nigeria did not want the country to be one. And Britain was not going to give up independence separately. Because they knew that if they gave the North independence, the North will always depend on them. That's why the North did not want independence in the first place. They didn't want independence. So, but as I said, this is the beauty of the law, is that I am absolutely specific in what I'm asking. Is the 1914, the Act of Amalgamation of 1914, is it a breach of undertaking? That's the first question. If it is, I want the court to remove that breach of undertaking. Because it is still law. So they remove it. The judge can then turn around and say, I'm not giving you a penny, because, you know, if you're an animal in a cage and you've been in that cage for 46 years, you don't know where else to go. And then they open the cage and they say, oh yeah, that's the jungle. So you caged this lion for 46 years. You fed him everything. And then you open the gate and you say, that is the forest. Go and find do it. No. No. I want this argument that we're having right now. I want you to we need to discuss the interregnum between the time that we got independence and now. And as I said, there are a lot of complicating issues, for example, which the judge might be interested in going through. That, okay, we had independence, we had a republic, then we had a coup, which then messed up everything else. But we are not interested. What we want the judge to say is simple. Is this a breach of undertaking? If the answer is yes, please remove the undertaking. Once he has done that, it is then left to us as Yoruba people to say, well, amalgamation is no longer, because don't forget, the Act of Amalgamation was Nigeria's first constitution. That was the founding, people don't realize it, but that was the founding constitution of Nigeria, the Act of Amalgamation. That's the constitution.
You know, the problem I have now, which I'm trying to get clarification on, I'm not disputing that, yes, most of the problem came from the amalgamation. That's why I said earlier, let's look at in two parts. Unless you can convince me that the act of the amalgamation is the part of reason why we are still part of Nigeria today, because we cannot do anything about it. That's number one. Then number two, the analogy of the drink. Let's apply that. Imagine somebody, which is similar to what you said about somebody bought a drink and give it to somebody else and he drink it. Yes, the obligation of the manufacturer or the brewer is still, he cannot deny that. However, supposing the manufacturer put a statement out, I realize there are some problem with the product I produced. I'm now recalling, and everybody who bought that drink should not drink it, and make sure that you don't drink it, and make sure you give it back to the retailer or wholesaler, and you can claim your money back. But somebody, for whatever reason, decided not to comply with that request, and then decided to drink it and then pour you. What will happen then?
You have assumed that the man willfully, knowing that the thing is poisoned, he then willfully took the poison. That's a different case. He willfully.
No, I didn't say that. No,
he knows. No,
he knows the product has been withdrawn.
Yes.
Yes, it's been withdrawn.
Yes, so he then willful negligence.
Yes, and
that's willful negligence.
Yeah,
that's willful negligence. But what we are talking about is totally different.
Yeah.
Remember what I said? You are in a cage between.
Oh, I'll give about that. Yeah.
You then let us out of the cage.
Yeah.
And then you expect us
to go now. Run your own business.
Yeah, but in fact, I mean, we can, we're not running our own business.
Hello, sir. I'm just playing the devil's advocate,
I like it. That's what I'm saying.
All right.
I like it.
So I think
the argument. That is the discussion I've been having with my lawyer.
We will postpone the discussion because now we have exceeded our time, because I can see that both of you are really enjoying the discussion. So it is funny.
That's fine.
When you see when you try to out of the situation, out of the problem, another one will occur. That is the situation of Nigeria today. So it is so complicated when it comes to the law, amalgamation, this and that. You see that it's very complicated. You will just be from one room, enter to another room, from another room to enter to another room. So
it is not complicated at all.
But the government make it complicated, because if it is very easy, sir, if it is very easy the way you have said it now, those who are fighting for the freedom should not be arrested, should not be chased away from their own town. Some will not be said. So at least, even though when you are trying to fight for your freedom, they will always said you are trying to cause the breach of peace.
Let me tell you what you have just said. It is against the law of self-determination, to which Nigeria is a signatory.
Yeah, but the government is not following it.
Determination. That's what the law says.
Yeah.
That's what the law says. The fact that Nigeria is a lawless country, in fact, makes it easier to make the case to leave.
Can I then ask you, sir? Then, it's just like the analogy which I also want to use, that somebody wants to divorce their husband or wife, okay, and you do everything, but yet the other party doesn't want it to go. We know, especially in matrimonial law, for instance, if you separate for a couple of years, I think, is it 3 years? I can't remember exactly. But it's automatic divorce, isn't it? However, even that happens, and you still want to stay together, because we've seen cases whereby people still stay together and have many, many kids after when technically they are divorced. And
Well,
like it's the same case with Nigeria.
You are still talking Pavlovian. It's the same thing that happens to abused wives.
Wife.
When a woman is in an abusive situation,
relationship,
and has every opportunity to run away and doesn't, but the law does not say it is her fault. The abuser is the abuser. The fact that you have not run away does not change anything. The abuser is still the one that faces the wrath of the law. You cannot blame somebody who is being abused because of this thing that we are talking about, brainwashing, Pavlovian. That's what's happened. These people kept us in the same cage for over 40 years before we got independence. By which time, it's around to what to do. I mean, if Britain had supported, for example, Biafra would be gone by now. Don't get away from what I set out to say is this. We had a treaty with Britain in 1888. In 19taking that British the court to tell that undertaking was breached.
Britain was complicit right for beginning or no. And that's why I had that question in two parts earlier, saying, yes, you're absolutely right in the first part. However, the second part, the stage where we are now, I personally think if we want to go, I don't think it's up to the British anymore for us to say, you know what, we've had enough. And we are taking our sovereignty back.
Yeah, but that's not got anything to do with the fact that 1914 was a breach of undertaking. What you are talking about is a totally different thing entirely about how do we get out of Nigeria. And the reason why I go down this path in which I try to explain this sort of thing to everybody is this, that we seem to be completely lost. We don't know what to do. This is the Pavlovian thing. I was talking to your forum the other day.
Yeah.
That what we are doing as Yoruba people is that we are forming so many organizations in the hope that one of them will produce a Moses, a Messiah. It's not going to work. It's not going to work. If the Oba today form a group of themselves, a conference, and declare Yoruba nation, we will be gone tomorrow. Don't let anybody who tells you that but they're not going. If they're not going to do it, we activists need to find other ways of doing it. And I was, and I was trying to explain how we can use the UN processes to achieve that thing. This is another way of doing it.
Ẹ má jẹ́ kí agbára wa ní àkókò.
Thank you, Dr. Oni. Thank you.
Ẹ ṣé gan púpọ̀.
Just one final point I want to make, please.
All right, sir.
I am interested in setting up a group of Yoruba lawyers in the UK so that we can discuss these things, amongst the legal people and decide how to go forward. I think we need to stop talking. We really need to do something other than talk. I am prepared. So any lawyers out there who's listening to this, if you're interested, contact me with your phone number and I will arrange a meeting of the lawyers. I will put my ideas forward to them and then we can discuss how we are going to actuate it so that we stop talking all the time. The law is there. Let us come together and see how we are going to use the law. Thank you.
Thank you, sir. Yes, and by the grace of God, at least we have a Yoruba professional lawyer who are living outside the Nigerian, at least who have an interest in what you have just said. So I to pull the house, Tabato Tinshe program, then by our next program, we will display your phone number and your email so they can have a minute to contact you. Actually, when you watch Dr. Oni àti Daddy Member Sam Lambe wọ́n ti jọ ń fi omi jọ látàárọ̀ lérí tí ọ̀rọ̀ Nàìjíríà nítorí lórí fún wákàtí kan ó lé díẹ̀ ètò tí èèyàn ti gbádùn tẹ́sí láìpẹ́ ẹgbọ́n ẹ tún lọ tún àwọn ètò ẹ tún lọ máa tún wọn wò àwọn ètò tá à ń ṣe lórí ìmọ̀ràn àgbà ẹ lọ máa tún wọn wò lágbọ́n Ọlọ́run nígbà tí a tún máa pàdé ní ọjọ́ Thursday fún another episode ní àgbọ̀ Ọlọ́run wọn ní fẹ́ lómi wọn ní fi iṣẹ́ náà kan wá ní àgbọ̀ Ọlọ́run ibi yìí òun náà ni a ó fi àdàgbẹ́jọ́ tó ní rọ̀ sí láṣẹ Lédùmarè oníyanṣẹ́ ọlọ́bẹ̀ṣẹ́ ẹ tẹ́ bá wa jẹ́ náà ẹ kú àìbínú bóyá ní kí n máa kí àwọn bá wa lé pé àwọn gbádùn àwọn ètò yìí ẹ ṣé púpọ̀ ẹ ṣé gẹ̀dọ̀ Olódùmarè yóò máa bọ̀dọ̀ nítorí tó wà fún ọ̀nà ni pé kí ara wa lọ kí alára wa lọ́yẹ̀ láti mọ tí òfin sọ nípa ohun tí à ń fa kíkan ṣe bí a kàn máa pariwo lásán pé kí ni tí òfin sọ níbo ni boundary wa níbo ni limit wa dé ọ̀nà ni àwọn tí ètò yìí tó wà fún Olódùmarè yóò ràn wá lọ́wọ́ ibi yìí ọ̀nà ni a ó fi àdàgbẹ́ tuntun títí di jọ́ Thursday tàtún máa pàdé ayọ̀ àti ìdùnnú ọ̀nà lèmi àti yín pàdé ó dàárọ̀ kí èmi àti yín kájọ fi ayọ̀ àti ìdùnnú kájọ fi pàdé a ò ní tójú oorun lójúkú ẹ ṣé púpọ̀.
ẹ ṣé o, thank you.
nígbà wo lẹ́ẹ̀kọ́ sọ nígbà wo lẹ́ẹ̀panupọ̀ sọ̀rọ̀ nígbà wo ni bẹ́ẹ̀ ni yóò jẹ́ bẹ́ẹ̀ ni bẹ́ẹ̀ kọ́ yóò wá jẹ́ bẹ́ẹ̀ kọ́. Yorùbá àtẹ̀yìn bàbá wọ̀nyí ẹ̀ ń sùn o ẹ̀sùn ẹ̀ ń ṣáàṣù o níbi ẹ̀sùn dé ẹ̀ ń ja ohun pa ẹ̀fún hun ẹ̀hún bẹ́ẹ̀ bá hun nígbà wo ni tẹ̀m̀bẹ̀lẹ̀ fún ọ̀tẹ̀ kẹ́ni má ní ìjà ipò ìjà ìlú yóò dópin láàrin yín gan-an ogun tá ń bá yín jà ogun ẹ̀kúlé ń bá yín jà èyí fúnra yín tó ń wá ń kọjú ìdá síra yín etí ọmọ ṣe ẹ̀kọ́ òkú ọ̀dà náà yàrá.